everyone to workers' compensation, or California workers' compensation to be precise, a basic overview. I'm Mike Falati, chair of the Workers' Compensation Law section. I am myself a certified specialist in workers' compensation law, but that said, I too can always use a basic overview as a refresher. The workers' comp section is a new and growing section of the Beverly Hills Bar Association. I encourage all work comp practitioners, as well as any practitioners in any overlapping interconnected fields like employment law and PI, to get involved with the workers' comp section. That can be by just attending the webinars such as today, coming to networking events, or even getting more involved as a section leader. I'll throw my email into the chat for everyone who wants to get in touch with me to discuss the section further. And now, without further ado, I'd like to introduce our speaker for today, Alexander McKay, who will be giving us a basic overview of workers' compensation law. Alex McKay is an attorney of counsel with NorCal Advocates, where his practice focuses exclusively on representing injured workers. His work covers the full range of California workers' compensation claims, including complex and consolidated cases, ADR and collectively bargained programs, Labor Code Section 132A discrimination petitions, serious and willful misconduct petitions, and major injury claims involving traumatic brain injuries, amputations, and severe burns. He brings nearly a decade of experience in the workers' compensation system to this session, and he has received a Whitkin Award for academic excellence in negotiations and settlements during his legal studies. Now let's get started. Alex?
Thanks. Give me one moment. Okay, so thanks again for that introduction. Again, I'm Alexander McKay. I'm an applicant's attorney, which is the term of art for a plaintiff's attorney. I've been representing injured workers for the better part of a decade up in Northern California. I've had a chance to appear at most boards north of Bakersfield. Pro tip, if you ever get a chance to go to the Reading board, highly recommend it. The board sits kind of over the Sacramento River, really nice views. Driving out there, not so nice, but is worth it. In my time, I've represented dozens of injured workers, but because I'm an applicant's attorney, well, my advice is going to be coming from a place where I can speak to the injured worker and litigation process, really don't have a great handle of how workers' compensation functions from the defense end. So the plan for today is we'll be spending just a moment going over some very brief background about the history of workers' compensation and how we have the workers' compensation system that we do today. From there, we're going to go over the 4 primary benefits of workers' compensation and to spend some time getting a basic understanding of those. And then once we cover those 4 benefits, we're going to talk about the progression of a case and how we see those benefits come on and offline and kind of mix and change our trajectory of a workers' compensation claim from beginning to end. After that, we're going to spend a little bit of time touching on some unusual aspects of the workers' compensation process before ending with a Q&A. Believe we're going to have a Q&A or a Q&A prompt. If you have questions, go ahead, plug those in. We'll get to all of your questions and answers at the end because it probably doesn't surprise anyone, but I did pretty okay at Trialad, pretty terrible at moot court, and I'm not going to make you suffer me trying to answer a question and then getting back into the flow of things. So if we're all ready to have a good time, that would be kind of weird. I'm assuming we're all here for the MCLE credit or to learn about the workers' compensation process. But if that's you, buckle up. We're going to get started. So the workers' compensation system is a benefit delivery system. It's a little misleading because workers' compensation cases are kind of referred to as the injured worker versus the employer and any applicable insurance companies, but it isn't originally supposed to be such an adversarial system. Workers' compensation in California is also an incredibly old and well-established program. Compulsory workers' compensation coverage started in 2013 and has been evolving ever since then. One of the unusual aspects of workers' compensation is that reforms have kind of come through and drastically changed how workers' compensation is practiced. There were a set of reforms in the 1990s, in 2005, most recently in 2013, which creates workers' compensation as an unusual area of practice where a lot of the precedents and case law for some of the foundational concepts are still applicable from case law in the early 1900s, but trying to practice workers' compensation in the modern era versus 2012 are completely different. Workers' compensation is also an incredibly prevalent system. Every employer in the state of California is supposed to have some form of workers' compensation coverage. Even my law office, that currently has one employee, has a workers' compensation process, has a workers' compensation system in place. Um, there are multiple ways for workers' compensation to be provided to employees. More often than not, workers' compensation coverage comes from a policy that's purchased in the open market. It's how we see our Berkshire Hathaways, our Hartford, Zurich's come into the workers' compensation system. However, there are other ways for that workers' compensation coverage to be provided. There are self insured employers. This used to be the vogue a little while ago with Walmart, Target, and massive corporations who have enough liquid funds and solvency to be able to run their workers' compensation claims, but seems to be falling out of practice. However, most counties and state offices still do self insured employment. If for some reason there is not any workers' compensation coverage, then an injured worker is still able to get workers' compensation benefits through the Uninsured Employer Benefit Trust Fund. That tends to be a more difficult process, but it is a way to make sure that injured workers are not left out in California through malfeasance or a lapse in workers' compensation coverage from the employer's end. Something important to keep in mind is that workers' compensation coverage is strictly for employees. Back in back when Prop 22 was coming around, due to how California was restructuring the employment, how it conceptualizes the employment relationship, switching from the Boreal factors to the ABC test, Prop 22 came around and kind of clarified that independent contractors and gig workers, such as Lyft drivers, delivery drivers, are able to maintain that independent contractor relationship. They do seem to have, or at least from my experience, Lyft as a workers' compensation-esque process, but it's pretty hostile to attorneys and is largely geared towards getting those independent contractors to be able to take care of their claims on their own. While there are multiple ways for workers' compensation coverage to be extended to workers, there are also multiple ways for workers' compensation matters to be addressed. Typically, a workers' compensation case is filed with the Workers' Compensation Appeals Board, or WCAB, if you want to start using some of the jargony terms of art. But some unions are able to enter an alternative dispute resolution program where they'll have disputes about providing workers' compensation coverage heard through mediators, and if issues are irreconcilable after that, go to arbitrators. This happens in lieu of a workers' compensation appeals board process and also allows the union and that employer to exercise a lot more control over the mechanics of the workers' compensation process. So they can come up with their own ways of completing discovery, their own ways of writing injuries, and really being able to, in theory, put together a system that is more responsive to the needs of the employees. And I believe the theory is less expensive for the employer. So, We're going to move on to our first benefit and really the heart of workers' compensation, which is industrial medical treatment. In workers' compensation, medical treatment is provided to injured workers as reasonably required to cure or relieve the effects of the injury. While this sounds simple on its face, like everything in workers' compensation, it turns out it's all terms. Reasonably required to cure or relieve the effects of it. The injury is defined according to the medical treatment utilization schedule, which is a document published through the medical unit of the Department of Industrial Relations. It's basically a giant list of objective evidence that is necessary for any treatment a doctor requests to be provided. So, for example, if someone has a back injury and it's eventually shown that it needs surgery, the medical treatment utilization schedule wants folks to have tried less invasive treatment. So wants to see folks went through physical therapy, got medication, got imaging to make sure that there's something surgically correctable. And that entire list basically boils down to what MUDIS is supposed to be providing. The way this is enforced is through the utilization review and independent medical review process. So, workers' compensation has this fun quirk that a lot of injured workers learn at their first doctor's appointment, which is that they don't necessarily leave with a prescription from the doctor's office absent emergency circumstances. What they leave is with a request for authorization. So at the appointment, the doctor will see the injured worker, go over what the injury is causing, and then basically send a proposed plan for treatment to the insurance company requesting authorization for that plan. From there, the adjuster concurs with the doctor, they'll authorize treatment, and then it's provided to the injured worker. If the insurance adjuster does not find the doctor's rationale for providing that treatment to be persuasive, they'll send it on to a utilization reviewer. And the utilization reviewer is just another doctor that goes through medical records, sees if they concur with either the injured worker's doctor or if they concur with the insurance company that the treatment is to be provided as medically reasonably or required or not. And if the utilization review process comes back with an adverse determination for the injured worker, that can be appealed up to an independent medical review doctor, which basically just runs the same system again. As you can imagine, a lot of steps to the process, takes a lot of time, and injured workers tend to not have the patience you would expect them to have, reasonably so, considering medical treatment essentially becomes a list of suggestions for an adjuster to see if they agree with or if they are going to test their interpretation of what's going on with other doctors. Another aspect of the workers' compensation process is that the insurance company is able to more or less control the physicians an injured worker is able to see. The insurance company sets up what is called a medical provider network, which is just a list of doctors that are approved to treat injured workers through their system. Frequently, there are limitations on the number of doctors, especially in rural areas. And if the medical provider network is not sufficient to meet the regulations for being applicable, the injured worker can treat out of that network with any doctor willing to see them through workers' compensation. This moves us on to our second primary benefit of workers' compensation, and the one that injured workers tend to think is the most important, which is temporary disability benefits. Temporary disability benefits are a wage replacement benefit that's paid to an injured worker when they cannot return to work due to the injury. There are a lot of components in there, but a wage replacement benefit is 2/3 of their average weekly wages. California workers' compensation does not compensate lost wages or anything like that, which is a disappointment for a lot of workers, for a lot of injured workers. to learn while a lot of their life is in flux due to an injury. Another feature of temporary disability benefits is that for most injuries, um, temporary disability benefits are limited to 104 weeks or 2 years of payments within 5 years from the date of injury. In some select injuries, folks can receive 240 weeks, but these are very specific injuries and severe injuries where we're expecting folks to need a lot more time recuperating. So this is for amputations, high velocity eye injuries, hepatitis, the types of injuries that are generally going to be pretty life altering, and the 240 weeks is a way to extend folks some additional time to make sure that they're able to adjust. Another feature of temporary disability benefits is that they can be paid in broken periods, which is a very helpful feature for seasonal workers and workers who are returning to work on trial basis. So these temporary disability benefits can come online while someone is out of work due to the injury, then be stopped for a trial return to work, then resumed after. This is applicable for seasonal employees because typically folks are only paid when they are in season. So, for example, if someone has an agricultural job and comes out for harvest season and they only work from July to December, temporary disability benefits would only be paid from July to December. On the other hand, temporary disability benefits is not limited to just the employer at issue. So that average weekly wage allows an injured worker to bring in all their sources of income. So if there is concurrent employment that an injured worker is prevented from being able to do due to the injury, that concurrent employment is factored into their average weekly wage, and the liable employer and insurance company are responsible for paying 2/3 of all of their wages. For seasonal employment, if our agricultural worker has another job from January to June, effectively being a full-time worker, just seasonal at this one employer, temporary disability benefits would run to the extent that the injury is preventing that injured worker from being able to do their other concurrent employment. There are typically three ways where temporary disability benefits end. The major reason for temporary disability benefits to end is when a applicant returns back to work. Work they can return to can be full duty work, so they are just returning to the job they had before they were injured. It could be modified work, so returning to that job, but with lifting restrictions or standing restrictions, braking restrictions, changing their workplace to an environment that is conducive to them actually continuing to be able to recover and work, or alternative duty, where we see a lot of injured workers be sent to Goodwill or other thrift shops to be able to work at that facility, which is typically pretty light labor and gets the injured worker out of the house. Another way that we see temporary disability benefits end is when an injury reaches what is called MMI or PNS status, stands for maximum medical improvement or permanent and stationary status. You can go ahead and put a pin in that because we're going to be spending some time talking about what that is and how it affects benefits. The other way that temporary disability benefits ends is when the statutory limit is reached. If 104 weeks pays out on an injury that does not qualify for that higher rate, temporary disability benefits end. And with temporary disability benefits spoken to, we get to move on to our third primary benefit of workers' compensation, permanent disability benefits. This is the compensation part of workers' compensation. So if you've been holding your breath waiting to get to this, take a deep exhale and a new breath. And also, congratulations, you've been holding your breath for quite a while at this point. But the compensation is paid for the compensable impairment of the industrial injury. And impairment is just the term of art that describes lost functionality. So if someone has a shoulder injury and can no longer lift their shoulder above their head due to the injury, we would call impairment that limitation between shoulder height lifting and being able to lift over it. That impairment gets described through a book called the AMA Guide's Fifth Edition to Permanent Impairment, and it turns those objective measures of impairment down into what's called a whole person rating. So this is just a percentage that roughly quantifies that impairment level. Fun fact, I know that the AMA Guide's fifth edition is out of date and could use an update because there's a sixth edition. However, current California law forces practitioners to use the fifth edition. And so we are continuing to operate with quite literally an outdated version of the guides, but it is what is currently used and mandated by the state. Once we have our whole person impairment rating from the AMA 5th edition, that impairment rating is able to be adjusted to the injured worker to make sure that the compensation is more closely tailored to their needs. Or more closely tailored to how is labor disabling. The way this is done is that whole person impairment is modified through what's called a rating string. So based on the body part that is injured, the whole person impairment assessed, we then start modifying that by its impact on future earning capacity, the type of job that they had, and how that is affected by the limitation of work, and then their age. The idea being a foot injury to a carpenter is going to be a lot more labor disabling, entitle folks to more compensation than a foot injury to an attorney where most of the day is keyboarding and speaking. Once we have our permanent disability rating, so that whole person impairment turns into a PD percentage, then that PD percentage matches a number of payments that are made to the injured worker. Permanent disability benefits begin once temporary disability ends, in most cases. This allows for continuing financial benefits when injured workers have an injury that is stabilized and they're not otherwise receiving temporary disability benefits to continue to have financial support when they're unable to return to their job. However, the current limit of permanent disability benefits is $290 a week. Is $290 a week. And he's very excited about statutory limits of workers' compensation benefits. But the current limit is $290 a week, which is significantly less than what most folks receive from temporary disability benefits. So the transition from temporary disability to permanent disability benefits tends to be quite the shock for most folks. A lot of practitioners will help injured workers navigate this financial difficulty by having them apply for state disability insurance through the Employment Development Department in California. And at that point, folks will then start receiving differential benefits where EDD will pay SDI benefits to get the injured worker to an overall income that is closer to what they were receiving through temporary disability by adding on to the $290 payments or whatever the injured worker was receiving as far as PD payments go. How PD can start paying out, even if there is not a whole person impairment percentage or PD number to pay out against, is that the defendants are required to advance a reasonable expectation of impairment when the injured worker has not returned to work and temporary disability benefits have run out. The idea is that everyone generally kind of understands that the guides will provide some impairment to some injuries, and we can usually kind of estimate where that would end up, and defendants can start advancing against that. Um, Again, it's a benefit to an injured worker because it allows for some level of continuing financial benefits. Employers do get to take credit for a benefit that they're basically conceding the injured worker will ultimately receive. If um, if permanent disability benefits have not started advancing because someone has returned to work or something else has happened, when permanent disability benefits are awarded, they'll start the permanent disability payment date from either when the injury reaches permanent stationary status or right after temporary disability benefits have ended. That allows those weeks to accelerate, and the injured worker is able to receive more money quicker because, again, it is a benefit delivery system. Um, uh, Permanent disability benefits do start becoming pretty different as we get into higher percentages. So if a industrial injury results in permanent disability anywhere from 70 to 99%, then an injured worker is going to be entitled to what's called a life pension. A life pension is payments that continue after liability for the permanent disability benefits have ended. And that life pension is payments that are worth 1.5% of an average weekly wage for every percentage above 60. Again, it is a continuing payment and it goes on for the rest of the injured worker's life, but usually comes in significantly less than their PD percentage. But the idea is that these injuries are going to be very labor disabling and radically alter someone's ability to meaningfully support themselves with labor. Sorry. So the life pension payments are able to supplement that. Um, the other place where permanent disability benefits gets unusual is total permanent disability. So if an injury results in 100% PD percentage, then the injured worker simply receives their temporary disability benefit rate in payments for the rest of their life. This is exceptionally hard to get to the point where a popular rating app that was built by a defense attorney for turning whole person impairment into a PD percentage, whenever you reach 100%, would literally have a unicorn fly across the screen because, as you can tell, the defense attorney thought that actual 100% total permanent disability benefit cases are exceptionally rare. Um, it's also incredibly difficult to reach this point, and even if you have the medical evidence supporting the 100%, practitioners will almost always get a vocational rehabilitation expert to be able to speak to the person basically no longer being able to support themselves through labor. Um, Another example that comes kind of from the applicant side is when I was being trained for how to rate injuries and what the percentages mean. Um, my supervising attorney basically explained that hitting 100% is exceptionally difficult because if you are, in theory, incredibly disabled, but you still have the capacity to basically take tickets at a movie theater as an usher, you're not actually 100% totally disabled. Very disabled, but not 100%. Important note is that both the life pension and total permanent disability benefits are subject to cost of living adjustments, which means it is able to account for how long these benefits are intended to run and encompass the fact that costs are going to adjust over decades. Another aspect to permanent disability is also where we see how workers' compensation is different. So psychiatric injuries are dealt with very differently in California workers' compensation. This is mostly a feature of the 2013 reform. And one of the core parts of that reform is that compensable consequence psychiatric injuries are not able to result in additional impairment for an injured worker, which means if someone starts having mental health issues due to their orthopedic or other physical injury, they're not able to get those extra PD percentages absent a violent act or a catastrophic injury. Um, Returning to the theme of simple simple phrases are actually terms of art. Violent act is when someone is exposed to a pretty extreme force that is vehemently or passionately threatening. Um, Violent acts are typically instances where folks are hit with physical trauma so hard they go unconscious, amputations, or in life threatening situations like severe car accidents, um, catastrophic injuries. I don't believe that the case law is as well developed. I'm fairly certain that the on point case for a catastrophic injury was a wildfire firefighter who had severe smoke inhalation and suffered cascading organ failure. And that was deemed to be a catastrophic injury by the appeals board, which allowed the depression that was a result of the injury to turn into compensable impairment. Otherwise, injured workers can make that claim. They can receive temporary disability to the extent that those consequential mental health issues are labor disabling, and they can receive medical treatment, but they won't receive compensation. In addition to psychiatric injuries not having that compensable consequence payout, they're just harder to bring. So most workers' compensation injuries just need to meet a arising out of and in the course of employment or AOE COE, where basically if work is contributing to almost any any symptoms that you are having, that opens the entitlement to workers' compensation benefits. Psychiatric injuries need to reach 51% or a predominant threshold. So the majority of that symptomology needs to be due to work and not anything else. I suppose 51% is a little misleading. I've heard it called by at least one judge 50% and a feather, but 51% has just been the way I usually describe it to clients to really kind of iterate that it is more than just a 50-50 prospect. Also, in order to even have a compensable psychiatric injury, the injured worker needs to have at least 6 months of employment in order to be able to claim that, unless they qualify for the exception, which is a sudden extraordinary employment condition. Sudden extraordinary employment condition is, again, a term of art. It basically means that the injury and the compensable consequences for the psychiatric ramifications were wholly unexpected. Believe an on-point case was a manager at a big box home improvement store was walking around. Lumber fell off of a high rack and broke his leg, and that was deemed to be a sudden and extraordinary condition because typically when you're insuring a manager at big box store, you're not expecting their leg to get crushed by timber falling from the sky. In addition to those, there's an extra defense for psychiatric injuries, which is called the good faith personnel action. Good faith personnel action is a bit of a complex defense because there are medical and factual components to alleging it. But the heart of a good faith personnel action is that if an injured worker is bad at their job and they're suffering depression because they're being told that they're bad at their job, it's not going to support a compensable workers' compensation injury. And that brings us to our fourth of the four core benefits of workers' compensation. That's the Supplemental Job Displacement Benefit Voucher, or SJDB voucher, or voucher if you want to use the cool term of art. The voucher is applicable to injuries that occur after 2013. Another fun aspect of the reform. I believe before 2013, the level of vocational rehabilitation benefits scaled with the level of disability. However, that's now changed so that after 2013, after a injured worker sustains injury after 2013, if they have any PD from 1 up to 99%, they're entitled to the same level of vocational rehabilitation training via the voucher. An injured worker has entitlement to a voucher if an injury results in permanent partial disability, so there is compensable PD from the employer, and the employer does not offer regular, modified, or alternative duty work within 60 days of the first report describing that impairment. A couple of caveats to that is that the work needs to be a reasonable distance from where the injured worker lives. So injured worker living in Redding, California cannot get a job offer in San Diego, where it is impracticable for them to actually travel to San Diego to be able to participate in the job. And the job needs to provide at least 85% of their pre-injury wages. Job is also expected to last at least 12 months. Some fun aspects of this is that apparent that this labor code section has been read to basically mean exactly what it means by the Workers' Compensation Appeals Board. I believe the on point case is a injured worker was an incarcerated person who was injured on their work detail. After the injury had stabilized, their incarceration term had ended, so they were out of the prison and they requested a voucher. The prison said, "We can't offer you work because you were released from jail and we're trying not to encourage you to commit crimes, so no voucher because it's basically impossible for us to do so." And the appeals board awarded the voucher, basically saying something along the lines of, if a injured worker meets the qualifications, they get a job offer or they get a voucher. And if you can't provide a job offer, you're providing a voucher. The voucher is a $6,000 job or training benefit. Injured worker doesn't receive any of these funds. The defendant insurance company will hold on to the funds, and then a injured workers vocational rehabilitation program will bill the insurance company against that $6,000. Because that $6,000 generally cannot be turned into liquid funds, state of California will offer an injured worker $5,000 through the return to work supplement for having a voucher issued to them. The idea is that $5,000 can help injured workers make rent, cover groceries, actually have time to meaningfully participate in a voucher program. Means if someone receives a voucher, they're overall going to have an entitlement to $11,000 worth of benefits. 6,000 of those is locked in job or training. 5,000 is given to them to have time to use the voucher. But the state cuts them a check and doesn't really monitor and doesn't monitor how those funds are used. And now that we've covered our four primary benefits, it's time to put them all together and kind of describe the progression of a case. This is just the framework I use to think about workers' compensation cases, and I tend to think about them in these three phases: our delay phase, our discovery and treatment phase, and our maximum medical improvement phase. I find the phases to be helpful because the objective of what we are looking to achieve in the workers' compensation claims process changes in each of those phases. Flowchart also starts briefly kind of describing how benefits come online and offline. And we'll be able to kind of visit that a little bit later. So let's no longer delay, get to phase one, the delay phase. The objective of this section, or the objective of this phase, is to turn a workplace injury into an industrial injury that an injured worker is entitled to benefits from. I alluded to it earlier with the psychiatric injury portion, but a workplace injury becomes industrial injury when it's found to be arising out of and in the course of employment, which basically just means if work is responsible for the issues, workers' compensation benefits flow because it is industrial injury. This is echoed in California being a no-fault system, where, again, or perhaps for the first time, but California is a no-fault system, so employer malfeasance really doesn't matter and is in consideration for someone having an industrial injury or not. Don't worry, I haven't forgot that pin in employer misconduct. We'll get to it in just a moment. But California is a no-fault system, and this standard has been read to mean that even if, again, 1% of symptoms are caused by work, there's entitlement to workers' compensation benefits. This is functional because neither the medical treatment or the temporary disability or what are an apportional benefit. So there's no discount for 99% of the need for spinal fusion coming from anything other than work. If work is at all responsible for those spinal fusion and it's approved, the insurance company is on the hook for the spinal fusion. Same goes for temporary disability benefits. Where apportionment does come in is on the permanent disability. So if a doctor believes that the impairment is 99% from something else and only 1% from work, a injured worker is only entitled to that 1% of the PD. The other 99 is something that isn't paid out to that injured worker. That is the one apportionable benefit in workers' compensation. California also recognizes both specific and cumulative trauma injuries. Specific injuries are kind of the obvious injuries, and I've explained it to clients as specific injury is an injury you can point to. So if John is on a ladder, John falls off the ladder, John hits the ground, you point to John being on the ladder and hitting the ground. Cumulative trauma injuries are where there isn't a obvious specific instance of injury, but it is an injury that's caused by work. This is typically repetitive stress injuries, but can also show up in exposure claims, like if someone develops silicosis because they were exposed to silica dust without proper PPE, if someone is having a non-Hodgkin's lymphoma event due to Roundup exposure, that would be a cumulative trauma claim because we generally cannot point to one specific instance and tie injury to that. In the delay period, how this works is the injured worker will report the injury to the employer if it's not obvious. Typically, the injured worker doesn't need to report the injury to their employer. They're taken from the job site in an ambulance. Pretty safe, assuming the employer knows about the injury if that happens. But within one working day of the employer being notified that there is an industrial injury, the employer is supposed to provide the injured worker what is called a claim form. Some of you may have seen it before or have been exposed to it if you've been in a management position, but claim form is basically a one-page document at the back of 3 very long, small, fine print pages. But the claim form has the injured worker describe their name, when the injury occurred, when it was reported, what was injured, how it was injured, to quite literally put everyone on the same page. Once the claim form is completed, the injured worker is entitled to $10,000 worth of medical treatment. Um, they are not entitled to any other workers' compensation benefits. So any time that they miss from work due to the injury isn't compensable or isn't paid to them yet. There's also no payment of PD or voucher. They just have that $1,000 in medical treatment while the claim is on delay. On delay being before it's accepted or denied. After the injury has been reported, the defendants are charged with conducting a reasonable and timely investigation in good faith of the claim to determine if benefits should issue or not. Insurance has 90 days to complete this determination and decide if they're going to accept it or deny it. But frequently, that determination is made well before the 90 days. Again, if someone is taken from a job site in an ambulance, tend not to need 90 days to figure out if there's a workplace injury. But on the exposure claims, we can be a lot closer to that 90 days as the insurance adjuster collects records, sees if the injury lines up with what they were exposed to, and really kind of developing at least an initial impression of if there's reason to believe that the claimed injury is industrial or not. The $10,000 in medical treatment is also supposed to make that 90 days palatable for an injured worker. That brings us to how we wind down our delay phase. So the end of the delay phase comes with either acceptance or denial of the claim. Something important to keep in mind is that an acceptance of a workers' compensation claim can be a partial acceptance. And once it's accepted, the full suite of workers' compensation benefits run to the extent that the claim is accepted. So if someone were to claim a right wrist and left knee injury, the insurance company can do a partial acceptance and accept liability for a right wrist, but deny any liability for the left knee. That means that medical treatment, temporary disability benefits, eventually PD and a voucher will run to the extent that the right wrist needs medical treatment and is labor disabling, and the left knee is basically not entitled to any benefits, at least until we go through the discovery process. Denials of a workers' compensation case at this point are total denials. And the denials are either factual denials or medical denials. Usually, insurance will cite both sources for denial. So if there's a denial, they'll say that they don't believe that there's medical evidence to reasonably support the claim of injury, in addition to a factual denial. But factual and medical denials can be handled quite differently. So a factual denial can pretty much be taken to court immediately if there's no medical denial. And the factual denial would be if our man falling off the ladder says that he fell off the ladder on Friday, but the employer doesn't have record of him being at work on Friday. That would be an issue that a judge can decide because the judge is in a position to be able to decide if Joe was at work on a ladder on Friday or not. The medical denials tend to need a medical expert, and it's rarely as simple as a binary of there was or was not workplace injury. Frequently, we'll see treating doctors describe injuries as exacerbations. So they'll say that someone was at work, when the injured worker claims that they hurt their back, that, okay, you hurt your back, we provide some medical treatment, but this was an exacerbation, and the extent that work was hurting your back is resolved. Your back problems are just your back problems. So there isn't a workers' compensation benefit to provide to you once that $10,000 or whatever medical treatment was provided while the claim was on delay is over. This is typically given to a QME to determine if there generally was that exacerbation, so just a temporary issue that has resolved, or if there's a possibility of an aggravation where work caused the baseline of any issues to have adjusted up, and that medical treatment and workers' compensation benefits are then necessary to bring that new baseline back down to the original or cure or relieve it. Once we have an acceptance of the injury, again, we're done with the delay phase and we're now on to the discovery and treatment phase. Purpose of this phase for me is that we're now looking to get the full extent of the industrial injury addressed and identified, and to have the entirety of the injury brought up to MMI or PNS status. Um, the industrial nature of the injury is almost always handled through a qualified medical legal evaluator. MMI or PNS status is usually handled through that QME, but can be addressed through treating doctors. So the discovery phase is again just trying to find the full extent of the industrial injury. A QME is an independent physician who's able to conduct a forensic evaluation of the injured worker by going over their medical records, both from workers' compensation and outside of workers' compensation, if they can speak to the injury and help us develop that comprehensive understanding. They're able to perform an examination of the injured worker, and they're able to share diagnostics and other records that will help them come to an opinion about the injury. The QME is a powerful resource to provide evidence speaking to the basis of a denied injury, either to overturn it or affirm the denial. And the QME is also incredibly important to be able to have denied body parts brought into the claim by essentially speaking to them like denied body parts. So our risk knee example, an applicant attorney and applicant would be looking for that QME to provide evidence to bring our denied left knee into our accepted right wrist claim, and really kind of develop that full understanding of the industrial injury as claimed. That brings us to the and treatment part of discovery and treatment. Again, as we discussed a while ago, treatment is provided as reasonably required to cure or relieve the effects of the injury. And at this point, the purpose of providing treatment is to get to that MMI or PNS status. If you've had that PIN saved, go ahead and take it out because we're going to address it. MMI and PNS is the point where an employee has reached stabilization. The condition of the injury is unlikely to substantially change within a year. This basically means that the injury has stabilized. We're really not expecting major changes to come in recovery. The framing I use with injured workers is that maximum medical improvement does not mean that the injury has literally reached a point of maximum medical improvement. It just means that it has hit a point of stabilization where our expectations for recovery and treatment from the injury have kind of shifted from making decisions to see effects in the course of weeks and months. And after MMI, our treatment plans are more geared towards seeing how that recovery goes over the course of years. So not to mean that the injury is gone or resolved. It just means it has reached a point of stabilization. We're in a position to be able to kind of speak to the long-term future of care for that injury. Once we have that, that moves us on to our next phase. Something important to keep in mind is that all aspects of the injury need to reach that MMI PNS phase before we're able to move on to that next phase. So in our right wrist, left knee example, if the right wrist reaches that MMI PNS because it was accepted early, got a lot of medical treatment, we've been able to develop our understanding, and the left knee gets brought into the case and benefit system later because it was initially denied, then the entirety of the injury is not ready to move on to the next phase until our left knee is PNS, even if our right wrist has been PNS for months. That also means that we could see our temporary disability benefits and other benefits run to the extent that the left knee is now labor disabling. Once we've made it through our discovery and treatment phase, brings us on to the maximum medical improvement phase. Again, this is the phase we reach when our discovery is done and we have opinions that speak to all four benefits. So we know the periods of temporary disability, we know permanent disability due because the entirety of the injury has reached that MMI point and impairment has been assessed, and we know which body parts need medical treatment. We may not quite be at the voucher point yet, and that's just because the voucher works on 60 days, and that isn't controlled by medical information. That is just a employer determination, and that issue may not be ripe. But once we reach the maximum medical improvement phase, our objective then turns to being able to essentially close out discovery of the case and come to a disposition. Typically, those dispositions are stipulations with open medical award, compromise and release, or trial. A disposition of the case needs to be an adequacy determination by a workers' compensation judge. Adequacy just means that the judge believes the settlement generally makes sense based on the medical evidence and benefits that have been paid out. It is a little paternalistic, but it is a benefit delivery system, and at least workers' compensation was initially envisioned as something a injured worker is able to handle pro per. Brings us to the stipulations with open medical award, or as I call it, infinite workers' compensation. In this settlement variant, parties reach agreement on temporary disability benefits, permanent disability benefits owed, and the body parts that need medical treatment. This is where we see our PD start. That PD is made in payments every 2 weeks until the PD payments are exhausted, which point a life pension would kick in if that is part of it. And industrial medical treatment continues for as long as the injury is symptomatic, for life as necessary, which is why I typically, not in front of clients, but nickname this as the infinite workers' compensation variant. Because while the injured worker is entitled to industrial medical treatment for as long as the injury is symptomatic, it is the same industrial medical treatment that they've received up until this point, which means they're still working through the utilization review process and the independent medical review process. They're still subject to the medical provider network and all of the complications that entails. Another feature of the stipulations with open medical award is that when the stipulations are entered into, an injured worker can exercise a petition for new and further impairment within 5 years of the date of injury. And basically exercising that petition for new and further impairment just returns the case back to treatment discovery phase, where the idea is that we see if there is any impairment beyond what was entered in the stipulations. So if there is any additional PD, be able to re-execute stipulations, and that extra PD is paid out to the injured worker. This brings us to our second settlement variant, which is the compromise and release settlement. In the compromise and release, the parties reach an agreement that resolves the injured worker's claim to all workers' compensation benefits. So it ends an injured worker's access to temporary disability benefits, industrial medical treatment, any possible PD payments. You can't technically settle the voucher, but you can enter stipulations that do become disabling for the voucher are incredibly hard to undo. A compromise and release can be entered into at any time. You do not need to establish the industrial benefits like you do in a stipulations with a medical award, where you're stipulating to those benefits. And this actually ends a case. So the compromise and release can be entered into at any time. It's often entered into if there is extremely high litigation risks or or issues where parties would rather not continue through the process. Important note is that compromise and release settlement can only be reached voluntarily. Judge cannot force a compromise and release settlement. They can reject them due to an adequacy review, but they can't force them to come apart. Because the compromise and release settlement ends all workers' compensation benefits, that becomes the flip side to infinite workers' compensation as finite workers' compensation. Our final general disposition for a workers' compensation case is trial, which results in finding an award. This is where, for some reason, parties cannot reach stipulations or compromise and release. At that point, through trial and evidence, we can have a judge issue a finding an award, essentially order stipulations with a medical award in accord with the medical evidence. This is typically the worst possible option for folks because it is effectively stipulations, but at the end of an incredibly long delay process, even if you don't have to go through an appeal. But as I'm sure all practitioners know, no one is afraid to go to trial, but no one likes going to trial generally, and trial outcomes are very uncertain, which tends not to bode super well with folks who have already had severely diminished earnings and medical treatment that often has more questions and uncertainty than benefits. That brings us to our odds and ends. So California workers' compensation does acknowledge death claims, and fortunately, death claims are incredibly rare in my experience. If an injured worker's passing is caused by work, the decedents can seek death benefits. Death benefits are paid out depending on the number of full and partial dependents up to statutory maximums. If there are no dependents, then any death benefits sheet to the state through the death without dependents unit. In addition to death benefits, the injured worker or the decedent is entitled to $10,000 worth of burial expenses. If you've been really waiting to address that kind of funny feeling about California being a no-fault system, congratulations, we've now reached our penalties section. So serious and willful misconduct is the part of workers' compensation where malfeasance on the employer's part is actually considered. So if a injured worker sustains injury due to employer's serious and willful misconduct resulting in the injury, then a penalty can be assessed against the employer directly instead of the insurance company. In this case, the court is going to look towards the employer and its representatives essentially exercising quasi-criminal conduct, putting the injured worker in the line of an acknowledged danger. An example of this type of conduct that would likely see success for the injured worker in the S&W petition would be if an injured worker is injured after a manager tells them to not use a lockout tagout or lotto system when cleaning a piece of equipment, then the piece of equipment turns on and injures the worker. In that instance, it's pretty clear what the lotto system is supposed to stop, and by management telling them to ignore lotto, resulting in the injury, that will get us to where we need to be for a successful S&W petition. The other place where employer misconduct comes up is the 132A petition. 132A petition is when a employer takes adverse actions due to the workers' compensation process. This typically comes up in retaliation against an injured worker for filing a claim. So any adverse actions that are taking place against an injured worker, so demotions, significantly cut hours, if that's motivated by retaliation for filing the workers' compensation claim, that can be a penalty assessed against the employer. Also, if the employer interferes in the workers' compensation process, that can be grounds for your 132A petition. So if the employer is intimidating friendly witnesses or trying to suppress evidence, is where we could see a 132A petition come up and be successful for the injured worker. All right. Um, so that's the gist of the presentation. If there are any questions or if there are any questions, I'd be more than happy to start answering those.
Perfect. It looks like we have two questions so far. The first one being from Landwin. Is there a way to compel a worker to file a workers' comp claim instead of turning to the third party, thinking a dog bite of a delivery driver?
Um, Typically, no. However, if an insurance company thinks that there is reason for a workers' compensation to be claim to be filed, they can file on their behalf. It it usually doesn't come up, but we typically see these scenarios come up in cumulative trauma cases where where there could be multiple defendants. An insurance company will file an application against another defendant to bring them in so that while medical benefits are not apportionable for the injured worker, it is apportionable as far as payment goes. So insurance company could file to bring that in. Um, but typically injured workers are not compelled into the system, um, and most end up in that system anyway because doctors will funnel them into workers compensation if they are seeing a patient non-industrially, kind of discover that workplace element. So generally no, but it can come up in rare circumstances.
Looks like we have another question. How does remote work arrangement or hybrid affect determination of workplace injury?
Yeah, so this is a new area that's come up. Um, Remote workers can file workers' compensation claims. It starts getting really fuzzy on AOE COE to make determinations about injured workers acting in the course of employment when they're injured or acting outside that course of employment. Um, there tend not to be a lot of witnesses, and this is territory rife for a lot of litigation to come up. Um, Workers' compensation has been dealing with this issue for a long time. Example is the coming and going rule, where if you're traveling out to work, you're not operating in the course and scope of employment, but if your employer sends you out to do an errand, you are. And my guess is we're going to be seeing a lot of those analogies become perfected as it's applied to remote workers.
Great, thank you. So that looks like, actually, no, never mind. We have another one. All right, so let's see. Are there any circumstances that allow an employee to bypass workers' comp altogether and sue the employer for negligence?
No, there aren't. In California, workers' compensation is the exclusive remedy for workplace injury. There are other workers' compensation can have a core with other claims of action. So if an injured worker is sustains injury because their manager beats them, so physically assaults them, resulting in injuries. It could be that would almost certainly be a workers' compensation injury, and there may be crossover with employment cause of action. But as far as just the injury goes, California workers' compensation is the exclusive remedy. Those other actions would be geared towards the misconduct of the employer.